there seems to be a need for some balance in this area. After a certain number of years, a person ought not to have his record follow him forever, I think, unless it's something of a very serious nature. And we are finding that employment opportunities are being denied to people simply because they had an arrest as a juvenile, and for the rest of their lives they are being haunted by some kind of activity which occurred at a very early age.
Assemblyman, are the current hearings pertaining to records, court records, an outgrowth of Governor Reagan's recent statements of relaxation on the names of juveniles being released to the public?
No, this is a study which our Criminal Justice Committee has been engaged in for some time to, on the one hand, see whether there may not be constructive programs in the area of juvenile delinquency prevention, and at the same time to indicate a concern about the promulgation of records of juveniles. The question of confidentiality of these records, how far they're circulated, how many years after a person becomes an adult these records are still around, and so forth. These are the two interests that our committee has and which we are trying to discuss today.
The Attorney General, of course, is talking about scrapping all sorts of criminal records, juvenile and other, except in major crimes after a certain length of time. Is this the general area in which you'd like to see things go for the juvenile system?
Yes, I think that the records, not only of juveniles but of adults, have to be narrowed down. We're keeping too many different kinds of records, and I think we have to start narrowing down the kinds of records we keep. I think that is part of the recommendations of the Attorney General as well.
What are the ultimate effects, say the arguments on both sides? There are those who are for keeping the records, those that are against it. What's the thrust of the two arguments?
Well, the arguments for keeping the records are basically that we need to have these records available for research. That's one of the arguments. We want to be able to follow people throughout their lifetime to determine what is happening to them. There are also those who want to have these records available for employment checks, and more harm to society in the long run by denying employment opportunities than the value of keeping these records.
So it borders on a violation of a juvenile's civil rights. Would that be an interpretation?
Well, this is still somewhat an unclear area as to how long records ought to be kept. And what we are trying to do here is to decide, if we can, to make recommendations to the legislature as to the methods of keeping juvenile records.
Assemblyman, we've heard in testimony this morning that various counties have various practices when it comes to releasing those records, this information, that judges pretty much have their own discretion. Are you aiming at some uniformity?
I think that's one of the things we're trying to get into. We found out this morning, for instance, that certain counties are sending their records to the state youth authority for certain purposes. Well, I'm not sure that's really necessary. And once these records get into the state files, there's no telling how far they may go. It seems to me that the purpose of these records basically are to help the probation department, which is a county function, and the juvenile court, which is a county function, and they ought to stay basically right there in the counties. And unless there's some overriding interest that we haven't discovered yet, I don't think the state ought to be involved in the record keeping of juveniles.
Do you have an opinion as to what kinds of Criminal Justice at the University of California, Davis is under grant to the LEAA, Law Enforcement Administration Act Assistant Office, to also perform some evaluations of the probation subsidy program. Now, they were down, spoke with us for a day a couple of weeks ago. I did some further discussion with them while I was in Sacramento last week. They obviously, in order to draw their samples, are going to have access to not only the aggregated data, but also additional data that would come from the hard copy files, and in those cases, names could be available to them. They were informed and knew in advance that they would have to seek an order from the presiding judge of the juvenile court to have access to that, and they haven't already submitted such a petition to Judge Hogaboom, and there's every reason to believe that in the case of this particular institution and its purpose, research, that such permission will be granted and that we will be authorized to participate with the Davis group in this study. Now, those would be the kinds of situations in which names could be made available. Also, being a county that has a large number of universities and colleges, we get almost weekly requests from both professorial staff and graduate students who are either doing term papers or master's theses or special studies in the fields of crime, delinquency, prevention, and so on. We provide information to them as a matter of policy without identification of persons. If they need to get into the files and have access, they too must go and provide us with authorization from the presiding judge before we can do that, and then it is done only under our supervision. The files are never removed or computer terminal to get into it. They must identify themselves and use the appropriate keyword for the day to indicate that they have authorization to get into these data.
So at this point, you represent that these cards, let's assume after 5 years, would not be available.
And storing them in the security vaults of the Justice Data Center. One of the problems is our limited access to the computer in doing that. Now,